Ned, are you gonna say anything to start, or should I just start myself?
No, I will. I'll kick us off.
Okay. Looks like we have 6 people so far.
Good afternoon, everybody. We're just gonna give it a few minutes, let everybody get joined to the webinar, and then we will get started. And you are all muted automatically as you come in. Good afternoon, everyone. Those that just joined, we're going to give it till about 2 minutes after, just to give everyone time to come in and get settled. Those of you who just joined, we're giving it another minute or so just to give everybody time to get in. Okay, we are sitting at 2 minutes after, so we're going to go ahead and get started. Good afternoon, everyone, and thank you for joining us. We're excited to have you with us today for what is not our first PNC rate filing webinar. This will be the first one in a long time. I know I have not privy to one happening in the last 10 years or so. So we're excited to have you today and have the opportunity to go over a few things related to PNC rate filings. My name is Ned Gaines. I am the Deputy Commissioner for the Rates, Forms, and Provider Networks Division here at the OIC. And with me today is Eric Slavich. He is our lead PNC actuary. He manages the PNC actuarial services team, and they are the ones that handle all those filings that come in. So just a couple of items. What we're doing today is we had some questions that did come in through the trades, and those will be covered throughout the webinar. You will have the opportunity, though, at the end, if you do have other questions that pop up, please submit those through the Q&A, and then we will get to those after Eric is done with his presentation. Anything that we may need to go back, do a little bit of research on, or if we run out of time if we get a lot of questions, then we will make sure to get those answered, and we'll send out an email with the responses. Everybody is muted, so if at the end of the presentation you want to actually ask a question or you have a comment, you will need to raise your hand, and then we can unmute you to allow you to do that. That's going to be time dependent, though, so best way is to do the question through the Q&A. That way we have a record of it, and if we need to get back with everyone, we can. So with that, I'm going to turn it over to Eric.
Okay, thanks, Ned. And I'll go ahead and get started. As Ned said, I am Eric Slavich, the lead property and casualty actuary here. I've been with the Insurance Commissioner's Office for 25 years. Most of that time, I was a filing reviewer. 6 years ago, I gave up most of my filing review work and took on the leadership role instead. And now I supervise a team of 5 filing reviewers, including one other credentialed actuary who, up to now, review all property and casualty rate filings in this state. Our basic idea for the webinar, as Ned mentioned, was we're going to get questions from insurers and use our time here to answer those questions. Here on the screen, we see a couple of the questions we received, and there are some additional questions we received after the slide was created, and I'll also be addressing those separately. The first one is more of a request than a question. Just as a little bit of background for personal auto filings for the largest insurers, 1% of the market share or greater, when there is a rate increase, we have a process called independent reviews where we do our own actuarial calculations to determine whether the rate increase is justified. Typically, for these filings, we ask for the data in an objection letter after reviewing the filing. And the question is really, is it maybe a better idea to get this data up front, give insurers a template or something where they can proactively provide the data and maybe short circuit this one objection process? And actually, it so happens that this is something we've considered before. There are some pluses and minuses to it, so we have never pulled the trigger on creating this template, but based on this question, I expect we will be creating the template in the near future. It will be optional, so you can still just go through the normal process and wait for objections. But given the desire expressed in this question, we'll get moving on this. I would say that it's not a automatic better way of doing it, because sometimes during the course of review of filing, it turns out that some of the objections we raise result in using different data. Like maybe the data are too old, or maybe just during the course of review, the data become old. And then when we do ask for it, we get something that's updated. So if you are one of those insurers and you want to provide this information up front and be proactive, that's great. Just know that it might also result in you having to submit the same updated data again later in the filing process. And I would say that this new template should be available sometime later this year. So the second question we've received was about whether OIC had considered hiring an outside actuarial firm to help us with filing review. And this is something we actually have considered a couple years back, prior to submitting a request to the legislature for additional staffing. One of the things we did consider at that time was, should we think about hiring an outside consultant? Our conclusion then, and still today, is that this is really not a good fit for us. Hiring someone on the outside is not going to be worth the trouble. Just trying to imagine lining up our expectations and our standards for filing review, training the outside consultant is just, we didn't think it was the right way to go. But there is good news on the staffing front. In the last legislative session, we obtained funding for 2 new reviewer positions. And in addition to that, we found some money in our existing budget that we could reallocate to my unit. And as a result of that, we are planning to hire 3 new people. This will bring us from 5 to 8 reviewers. And just to give you an idea of where we are in that process, interviews for these new positions started yesterday. So we're moving along. I mentioned that there were some other questions we received later that didn't have time to get into these slides, and I'll read those off and answer them. Is OIC open to publishing a template for independent review filings that filers could fill in for OIC? So this is similar to the data template question, but this is actually about the actuarial work and the exhibits. So the answer is yes and no. You can see our work if you want, but it really isn't feasible to just put it out there and have you complete it for us. Some of the pieces in the analysis are systematic, so those would flow through automatically. But there are some parts of it that are subject to actuarial judgment, and you can't do those for us. That's the independent part of the independent review. If you are interested in seeing our work, when you have an independent review filing, you can reach out to the reviewer and ask for a copy. Next question. What considerations does the OIC take when deciding to object, reject, or approve a filing? Well, this is a good question, but it's also extremely broad. I'll talk a little bit about the issue of materiality objections later on. That's in an upcoming slide. Rejecting a filing, that's typically for a type of problem we spot at intake that can't be fixed with correspondence. For example, we would reject a filing that combines rates and forms. We don't allow combined filings. If there's a filing with an attachment that's not a PDF, we don't accept those for the most part because they wouldn't download into our back office system. If it's the wrong filing type, we need to reject the filing. If it's not even a rate filing at all, which sometimes happens, we get like general correspondence submitted in filings, we'll reject those and ask the filer to just send us that correspondence outside of SURF. Next question. OIC objections often include questions on changes to previously approved factors, which understandably will mitigate rate change for existing customers. How should carriers weigh the need to reduce cross-subsidization across customer segments versus keeping rates stable for existing customers? Well, for this, I think the best approach is to avoid overreacting to your indications. Over the years, I've noticed that when we have a filing that refreshes the entire rating plan, we always get a lot of dislocation. So if you look at the histogram, you have a bunch of folks getting really big changes, like 40% or more, plus or minus. The thing is, the same insurer might then file another update to its rating plan, a year later, and again, you get this huge dislocation. And to me, this says that at least one of the two filings was wrong in some sense, if not both of them. What I would recommend is moving partway toward your indications for each factor, but not all the way. This isn't a legal requirement, more of a suggested practice. So I'm not going to tell you like how far to go towards your indicated factors, but I would suggest considering how you are disrupting your policyholders, especially when you think about it, not from the perspective of one filing, but looking at a sequence of filings over the span of a few years. If you do one big update every 5 years, maybe it makes sense to go all the way to your indicated factors. But if you're updating every year or two, maybe you want to take a more incremental approach to your selections. Next question. Would the OIC be open to allowing one flex rate approval per carrier each year? For example, New York allows a 5% rate change per year that is approved on a fast-track basis. This could help remove simple rate change only filings from the queue and free up capacity to focus on more complex filings. Short answer is no. I don't see how we could do that under the Washington Insurance Code. I will concede one little point about this, is that we do often consider recent rate changes when we're evaluating a new filing. If you had a lot of unused indication, call it, in your last filing, and your new filing is only a small increase, we may go into reviewing your filing with the thought that this one is probably going to be okay. And that can influence what we consider to be a material issue, which is something I'm going to discuss later. Next question. OIC has previously dictated that carriers cannot deviate from the indicated in factors. Will the OIC consider confidence intervals in their review of factors? Okay, confidence intervals. Well, for the most part, we will not allow you to select factors that are more extreme than indicated. But usually selecting less extreme factors is okay. And when I say extreme, I'm talking about basically further away from 1.00. So either too big of a discount or too large of a surcharge. We would not accept the idea of selecting a factor that is more extreme than indicated, even if it's within some confidence interval that you calculated. I mean, you can make a confidence interval quite large. And the main issue is that your rate should be based on expected costs, which corresponds to the indicated factors, not expected costs plus or minus some margin. Next question is, what can carriers do to help shorten the 45-day wait before filing review starts and the multi-month long delays in between objections? Okay, well, later on, I'll suggest some do's and don'ts and explain our prioritization process a little bit, which might give you some insight into the answers to this question. Unfortunately, how long it takes us to get to your filing initially or to get to your response after objections is pretty much out of your control. And I do think review times will be getting better as we add those new reviewers I mentioned. I should also mention that while our backlogs are still not what I would consider good, they have been improving. As an example, one of the stats I track each month for my unit is how many responses have been waiting over 45 days. It was recently at 0 for the first time since I took over in 2017. This was a couple months back. We're not still at 0, but still I take heart from the fact that we got there at least momentarily. Next question. In order to introduce innovation, new model upgrades may include brand new changes across many factors. Is there standard support that OIC needs to see? Not really. If you're going to involve credit factors, our regulations do require a multivariate analysis. And I think most insurers understand the benefits of a multivariate approach, even when it's not a strict legal requirement. If you want to ask for my preference, I think GLMs are easier on us than, say, like tree-based models. The main thing is that you do need to support new and revised rates and factors in some way. So let me move on here. So that ends the pre-submitted questions, and now I'll just cover some areas we wanted to mention. So one of the most common things insurers ask me before submitting a filing is something like, if I submit my filing next week, will it be approved by January? Or whatever their key date is. I always struggle with this question because review times vary so much. So here I've given you some data showing how many filings are approved in a given amount of time. I hope you find this interesting. So about 40% of filings are finished within 1 month, but it's not until around 7 or 8 months before 90% of filings are done. And even after a full year, there are still about 4% open. So hopefully that gives you sort of a vague answer to that question about how long will it take my filing to be reviewed. It depends. Also on this slide, I'm plugging our speed to market tools. We started posting these a few years back with the hope of improving the quality of filings and responses when certain issues were involved. I would say that our experience with these has been mixed. For example, I've seen several filings where we direct the filer to look at one of these tools, only to have them continue. We have to continue objecting to the same issue again, and maybe even referring to the speed to market tool again. Since the hope was that the speed to market tool would eliminate the back and forth, it's a bit disappointing to see repeated objections. We also got very little feedback from filers about these tools. So I would encourage you, if you want to see more of this type of thing, let us know what topics you think would be the most helpful to cover. If we do post more of these, we'll send out a Gov delivery notice. So if you're interested, I'd suggest signing up to that service so you get notified. So let me tell you a little bit about our review process. Prioritization is a big question. And I will just by the same thing next. But first of all, we finance and also objectives a little separate, so those two stacks are kind of separate. The other thing is we try to be aware of that our it's not take much time to finalize them. We call them quick. So think about reviews of a filing or sending an objection letter, and it's probably at that point that they're making themselves okay, it's possible. And we know that actually calls that to be reviewed probably and the other part is basically things are down to the processing. There's no TC left. A lot of times filing should be quick, but these files things and so we're going to go. So this is one day where it's for you to actually but you should be quick and so then after you have to agree is just keep in mind that it's not just about objects. It's still also over exhibits and mail pages and meaning even approval will take too much time for prioritization. But it's not about doing everything fast, it's about how long it's going to take us to confirm and verify that you did everything. And really we don't want to unfairly delay every other filing in front of yours with a lengthy review that's taken out of order. One of the questions before was about how we decide to object. Now, in the old days, back when I was a filing reviewer, we would object to pretty much anything and everything that was wrong that we saw. And it didn't matter whether the issue was about a specific statute or regulation or disagreement about actuarial judgment or method or typo, whatever. For example, it seemed like almost every filing had multiple objections about the return on equity and profit exhibits. Then some years back, as the filing backlog grew to unacceptable levels, one of the ways we adapted to try and move things along more quickly was to change our processes to avoid sending objections that were immaterial and which would not have an impact on the outcome of the filing, no matter how the objection was resolved. If you have errors in your profit calculations, but we can tell that the profit provision you ended up with complies with our regulation 284-24065, we no longer send that objection. Maybe we think you've selected too high of a provision for some expenses, but if we do a rough back-of-the-envelope calculation, we can tell that the selected rate change is low enough compared to the indicated change that it doesn't make any difference. We might do the same thing with trend. If your trend pick is a little higher than we think is reasonable, but we can still tell that your selection is in line with what we think the indication would be, no objection. We hope that this overall approach is something filers would welcome, though it does perhaps create situations that look a little strange, like, why are you asking me this when you didn't ask it of my competitor? Why are you asking me about this now when you were just fine with the same exhibit in our last filing? Why did one reviewer ask about this, but another reviewer looking at a different one of our filings not ask about it? So keep in mind that to us, the alternative to this approach would be to go back to always sending objections, even when we recognize they don't matter to the outcome of the filing. One point on this is to recognize that sometimes due to the nature of the error, we cannot tell whether it's material or not. An example of this would be sometimes we'll get an exhibit and it's labeled as, say, Virginia instead of Washington. And so maybe it's just a typo and the correction is to just change the heading so it says Washington. But maybe the entire exhibit is wrong and all the data is wrong. It's from the wrong state. So it might be the kind of thing that's not material to the outcome of filing, but we can't tell. So in a case like that, we would still pretty much have to ask. I want to talk a little bit about the complete manual request. So if you submit homeowners or personal auto filings, you are probably familiar with this. Sorry, I moved on. Ned, did you want to talk about something? I think I might have skipped where you wanted to chime in.
That's okay. I'll pick it up when you're done, right?
Okay. So typically the manual request, when we send a request for your final manual, what it means is that your filing is done, except for just data entry. But there have been a couple cases in recent history where there's been an issue. And what has happened is that we get a complete manual and we can't reconcile it with the filer's prior approved filings. And this is a problem. So it's the changes made to the rating plan are in addition to what was disclosed in the filing we were considering. And this is pretty unfortunate. It leads to extended review times. You know, we get to the end of the process, we think we're all done, we send the request for manual pages, and then we find out, oh, actually there's more issues. We have this inconsistency we need to fix. And it's really important to us to fix it because it really gets to the heart of the question of, you know, what exactly. So I have a couple of first, I'd miss if I didn't take this opportunity to put out my plea to please try to simplify your rating plans and condense them as much as you can. We're getting some extremely long filings with implausibly long rating plans these days. And one thing that's really long process over here is that filings to get unnecessarily long. Extremely long filing takes longer to review, obviously. So if it's your filing, that's going to take longer. But also, just the general background level of large filings is inflating average review times and pushing everyone's filings into longer and longer times to final approval. So I would request that you spend some time thinking about how to present your rating plan and exhibits concisely and in such a way that your filing is easy to review. Just because your premium calculation software stores your rating information in a particular way does not necessarily mean you have to present that information in exactly the same way in your filing. And that seems to be a regularly occurring style of problem where it looks like the filer is on their premium rating software and hit some sort of export button and it just spits out this gigantic table. I'm going to show you an example of a couple different ways of presenting information that results in exactly the same final factors, even though the presentations are quite different. So first up, here's a simple way. So this is just an example. I made up all these traits and factors. They aren't from any one of your filings. They aren't necessarily meant to be realistic. They're just for exposition here. So we have 4 different rating variables, and I'm showing them in 4 different tables. This is what I'm going to call the correct way of doing things for the purposes of the next few slides. Here's an alternative. Page 1, page 2. And I just want to give you a small taste of some of the challenges we face in filing review that really bogs things down. So in order to get this table, I generated it by listing every possible combination of risk characteristics on those 4 tables I showed you before, each on a separate row, and then just multiplying all the individual factors together. So the factors turn out exactly the same, just multiplied together here. So this table encodes exactly the same for all the tables I showed. And I should note that in actual filings, we've seen really big tables, gigantic tables, much larger than this brief example. And let me just highlight some of the problems with this approach. First of all, the text size. Now, you can probably read this, which is not how we get filings a lot of the time. A lot of the time, the font size is so small, you really have to zoom in to even read it. And yeah, we do have software, we have PDF readers that can zoom in, but it makes it really hard to compare information across pages. You zoom in, you zoom out, go to a different page, zoom back in. It's just very difficult. You might notice that some of the entries on this page are just a bunch of pound signs. That's Excel speak for there's not enough space in your column to display this number. This is something, it doesn't happen a lot, but it's a careless error. And if we notice it in your rating plan, we really have no choice except to send an objection. I'm going to zoom in a bit here. So this is a piece of that larger table, and I've hopefully made it a little clearer so you can see what's going on. First of all, I want to draw your attention to the tenure categories here. And this is a type of filing style that I'm hoping to get you to avoid. There are fake categories. And what I mean by this is if you look at these categories, the 0 to 11 month factors are the same as the 12 to 23 month factors. They're all exactly the same. So as a filer, you're choosing to break out these tenure categories into more rows as really necessary. And you have the advantage on us because you know, or you could easily know, that you have copied them exactly. But we don't know that. If we want to have any confidence that the 0 to 11 month factors are always the same as the 12 to 23 month factors, we have to verify that with excruciatingly careful review. So please don't do this. Don't create these fake categories. If all the factors are the same, combine them into a single category. A minor point, but one that I think is worth mentioning, notice that all the factors here end with 3 zeros. There is no need to show 8 digits after the decimal point for these factors. You obviously have to show enough digits so you aren't rounding or truncating unintentionally, but you don't want to show too many. Now, I know it doesn't make any difference because it's not going to change the number, but it makes it harder to read your exhibits. It takes up more column width, and it a lot of times will result in you making the font size smaller, and it's just a lot of clutter that makes it harder for the reviewer to scan through your document quickly. Probably the worst thing about presenting your rating plan this way is it hides the underlying logical structure, which is so clear and elegant in the 4 small tables I started with. And again, I'm talking about these 4. really clear what's going on, and that the factors are logical in relation to each other. But not in this one. So we can, and sometimes we do, copy sets of factors like this over to Excel and see if we can sort of reverse engineer the simple factors. But why should we have to do that? This point really gets to the substantive review of your proposed factors. How are we supposed to know that these literally hundreds, sometimes thousands of factors are all logically related to each other when this is what we get? Like, as an example, just checking that the factors change in a logical way when the number of minor violations increases in this kind of presentation is quite a challenge. I think that should be clear, especially compared to the sort of immediately obvious factors in the smaller table. So I would encourage you to always choose the simpler way of showing factors when you can. I know sometimes your rating tables are not like this, where the big tables were generated by just multiplying all the possibilities in the smaller tables together. There may be interactions between variables that make the simpler presentation not work. There may be rounding issues, and you don't have to get and you do have to get the factors exactly right to match how your premiums are calculated. But you can consider rounding issues and how it impacts the filing process at the time you design your rating plan. And maybe if you have a rating table with thousands of rows, you could consider whether this level of detail is really all that helpful, or if a simpler approach would be good. Moving on, another common issue that comes up when I speak to filers about upcoming filings is the use of information obtained not from the policyholder, the application, but from a third-party vendor. We have concerns about using vendor data. It could be unfair. Some folks might not be in the vendor's database. The vendor may have errors. Even if it's only a 1 in 1,000 error rate, it still would not be fair to that one consumer to rate them with the inaccurate information. If the vendor's data and the reality about the consumer are in conflict, many insurers seem content to use whatever the vendor gives them anyway. We consider that unfairly discriminatory. So when you're thinking about using a vendor to obtain data about a consumer, think of the vendor's data as like the default value, the starting value, and it's subject to change if necessary. Your rating plan should assume you, the insurer, are getting accurate information without regard to the source of that information. Consider whether it's even necessary to identify the vendor in your rating plan. If you think it is necessary to identify the vendor, ask yourself why. It's up to you, the insurer, to make sure you are using accurate information for rating. If you are uncomfortable because you fear using the vendor's data might lead to using rates other than your filed rates, perhaps this is not a rating variable that is accurate enough to use at all. Using mileage as an example, I would let your applicants and renewing policyholders know what mileage you have for them and give them a chance to dispute and correct the estimate. Do not require them to jump through hoops just to get the information fixed with the vendor. So, a couple more points about vendor models. We expect you to use current information every policy term, unless stated otherwise in the rating plan. This is sort of the long-standing default assumption that when a risk characteristic is used in a rating plan, we assume you're talking about that characteristic as of the time you're calculating premiums for that policy term. We don't want to see unavailable or missing categories. That would be unfairly discriminatory. I understand that sometimes when you're doing your actuarial work, you may not have complete data sets, and you might need to have a category about that. But in the rating plan itself, unavailable or missing categories should not appear. And the other common issue that comes up is insurers will submit a filing with references to model. They won't show what the model is. They won't want to file the model. It doesn't work. Your entire rating plan needs to be filed, and there's no way to keep it confidential. Let me talk a little bit about what happens after a filing is approved. Suppose you notice that in your approved filing, there's some errors, maybe a typo. In that case, we're going to want to reopen the filing and have you fix it. So it's important to keep in mind that only certain types of corrections are allowed. You can't just revise your rates. But if it's clear you made a mistake that needs to be fixed, we will reopen the filing. So maybe you got the decimal place wrong. Maybe you put the wrong company name on one page. Maybe one of your supporting exhibits shows a selected rate, but you copied it wrong into your manual page. In cases like this, you can have your filing reopened. And what you do is you send a note to a reviewer in the approved filing, requesting that the filing be reopened. The key thing that a lot of filers do wrong here is they don't explain the basis or the need for having the filing reopened well enough. We'll get something that just says, please reopen so we can make corrections. Well, what kind of corrections? Be specific enough so that the reviewer can tell, is this something that really needs to be done as a new filing, or is it something as a reopen and fix it kind of situation? And if there are substantive changes that aren't just typos, well, that's not something you can fix in the approved file. It's going to need a new filing. Now, technically, if the filing is approved but not yet in effect, we could reopen a filing and you can make changes, but we really discourage that because that opens up the whole review process all over again. So if you make changes, then there might be objections. And this is a filing that was, we thought was already done and approved. Now we're starting over. So try to avoid that if possible. And once the effective date is passed, we wouldn't allow substantive change anyway. You would have to start as a new filing. For changes those effective dates, you don't have to reopen the filing. Sometimes filers want to resubmit their entire rating plan just to change the revision date shown in the page footers, but we will generally not reopen a filing for that. The effective date of the filing is what is shown in the disposition. What's shown in the rate pages is not official as far as we're concerned. And if we did allow reopening for this, we would have to carefully check that the filer didn't make any other changes besides the date in the new version of the rating plan. And that's a lot of work for us for very little benefit. So just send a note to reviewer with the new dates. Remember that the new business date can be at most 60 days apart, and you have to get your request to us before your filing would otherwise take effect. I should say that before the filing is approved, you might send a post-submission update with the revised effective date instead. But try to be consistent in your approach so you don't confuse us. So if you always use the post-submission update, always just, send another post-submission update. If you make a practice of sending a note to reviewer to change the effective date, just do that consistently. If you start by sending both a note and a post-submission update, do that consistently during the course of the filing if you're updating the effective date multiple times. Again, this is just for during the review process before your filing is approved. After it's approved, you don't have a choice. You have to use a note to reviewer. You can't submit a post-submission update on an approved filing. Well, final thing, I did want to mention our new premium transparency rule just to keep it in your thinking and make sure you're considering how you're going to implement it. Here's some links, and this slide deck will be available on our website shortly after this webinar is done. There's a two-step phase-in process. You can see here, June of next year, you have to provide a reasonable explanation of increases if the policyholder asks. And then June of 2027, you must provide the notice for increases of 10% or more, and for anyone who asks. And from my perspective, the good thing about this is that for once, my unit isn't really the main entity responsible for enforcing this. It's not a rate filing thing. We're not going to get rate filings for it. So we'll leave enforcement of this regulation to some of our great colleagues elsewhere in OIC. And that is all I have for now. And it looks like we do have some time for questions if there are any.
Thank you, Eric. On the rate transparency, I do want to add though, while there won't be a rate filing required, there is going to be a form filing required in the second phase, because you actually will need to file the form that you're going to use to submit or to send out to your policyholders.
Yeah, it's not a bad overall caveat for the whole presentation. I am strictly a rates person. I don't think in terms of forms.
So we have about 12 minutes left. So if you do have questions, I see we do have one that came in. And that is, are there any specific recommendations for companies making their initial filings with the OIC?
Initial filings. Well, it's one of those questions that's so broad that it's difficult to answer. A lot of the stuff I've talked about today would apply even in an initial filing situation. The basic stuff.
One thing I would add to that is this your run-of-the-mill auto filing, or is this something new? Are you looking to do something, innovative, inventive? If that is the case, that may be time for us to have a pre-filing call. We typically don't do pre-filing calls because we want the filing to stand on its own and to have that record in serve. However, if you are looking to do something that's outside of the norm, those pre-filing calls are helpful because it gives you the opportunity to explain what you're looking to do. And it could possibly be something, that goes against our statutes that we would not have a way of allowing. So keep that in mind. And that would be my recommendation for when you're making an initial filing with us.
Yeah, I think there are just too many particulars to really give a great answer to that. For example, what are you doing for credit? Are you planning to copy someone else's credit factors? If so, do you know what their credit scoring model is? Can you copy that exactly? If not, well, that's an issue. Like I said, there's a lot of factors. It depends.
And we did get another question. How would you say that the loading tape problem, the complexity of filings and errors submitted by carriers, would you say the loading table problem make up the majority of problems that lead to delays? Are there any other issues you see routinely that slow the review approval process?
It's a good question, and it's difficult for me to say that it makes up the majority of the problem. It's more in the way of the outlier issue, right? So the exploding table issue, what it means is like a filing that could have taken an hour takes 8 hours. So it's sort of an unnecessary addition of time to the review process. I would say that the really lengthy filings we run into might have that, but they might also have a number of new rating variables that have problems with them. Maybe we'll go back to the vendor problem where the filer plans to just blindly use the vendor's output without telling us, where the score comes from, how it was calculated, and that sort of thing. Questions of unfair discrimination can really bog down the process, especially when the filer comes in with this idea for what they want, and if it just is not going to get past scrutiny as far as our unfair discrimination statute, it can take a while sort of going back and forth and discussing, what are the situations where unfair discrimination is happening, and for the filer to understand. But they need to rethink their approach.
Sorry, any other questions? No question. We did receive a comment. Great to hear the OIC is looking to make a template available in the near future for rate take. Is that personal line specific, or do you expect that template will be applicable for other lines as well?
So what I was referring to was the data we require independent reviews. That's just for personal auto. That's the only type of business that we do our own independent actuarial calculations for rate filings. And even then, it's only for your main personal auto programs for companies with 1% of market or more is basically the cutoff.
A couple things I did want to add. I know a few of you I have had conversations with previously, but I wanted to go back to and touch on currently how we do our reviews and how we do our prioritization of those reviews. That is something that I'm taking a look at. I haven't worked out specifics yet because it's a little complex, but I am looking at opportunities on our end that we could tweak the prioritization a bit versus the first in, first out. I mean, because on the surface, yes, that is the most fair way for us to do it. However, we also are cognizant of some of our larger carriers necessarily needing to take rate. And in the terms of fairness, is it most fair for the company with a very large market share to be behind the company with 200 policies in force in the state? Again, this is going to be a work in progress. I appreciate your patience as we do that. Any input that you would like to make on this, I welcome. And want to be a partner with the industry. Yes, we're going to make you follow the rules and follow the statutes, but again, we want it to be more of a partnership versus an us against them type of relationship. So, we do welcome the fact that you joined us today for the webinar. I hope you did find it useful. I'm going to put my email because some of you I know I've not met. I've only been in this role for a short period of time. Took over back in May. So some of you I know I've not met yet, but I'll put my email. If you do ever have questions, feel free to contact me directly. Always happy to take questions from the industry. If you found this to be useful, I would love to get your feedback on it and let me know. Did you like it? Is it something you would like us to continue doing in the future? And any other suggestions that you may have. I am not seeing any other questions come in. And if that is it, then we're going to go ahead and wrap it up. As Eric said, the slides will be available on our website. We did record this session. I'm going to have to work with my web services and see if we can also get the recording on. That way, if you have anybody that you'd like to listen in, they will be able to do so. So again, with that, we thank you for your attendance today, and we look forward to continue working with you in the future. Have a great day.